before I forget, woohoo! Hi to everyone at home. We are doing the tutorial for week 5 contract B, and we have just been catching up a little after the midterm break. As I was saying, I hope you've managed to get yourself kind of up to date with your readings and so forth, that you have the assignment under control. I am more than happy to stay behind and answer questions this evening in relation to the assignment, because the mentors and I have been having long discussions about the questions that they've been fielding, and I'm more than happy to troubleshoot with any other or whatever after this tonight. So let's book discussions. Mary's at the bottom of the garden. Yeah, let's discuss the assignment at the end. Apart from that, how have you been going with your readings? Because I'm really super keen to find out if people are managing to keep up with your readings, because contract B is one of those nasty little suckers that if you let it slip, it will come back and bite you in the bot. Shona's saying, yep, all good, awesome. Okay, do try and keep abreast of your readings, because this is not really one of those subjects that you can just kind of swat up at the end. Kind of just when you thought that the misrep week, the misrepresentation and misleading and deceptive conduct week was full, chock-a-block full of readings, heading into this half of term, we have a number of weeks that are fairly significant weeks that we'll need to get to. So I would heartily recommend trying to stay abreast of your readings if you can. Having said that, can I have some rough idea of people who have managed to have a look at this week's readings at all? Could I see a 1 for yes and a 2 for no? Just so I get a brief understanding. I don't mind one way or the other, but I just wanted to have a 1.5, love it. I just need to get a rough split of you know, who's actually gone through this stuff and who hasn't. Okay, so most people have not managed to look at the materials. Keith is 2. Okay, that's all right. I've watched the videos a little behind him reading. Does printing it out count? I know. I wish it would just soak in by osmosis. Oh, dear. I would heartily recommend. Illegality is one of those weeks where I would really recommend that you watch the videos probably first. I kind of worked hard on those videos to try and help you make sense of things in a bird's eye view kind of way, so that then when you went to unpack the text, it all made a little bit more sense, because the way it used to be organised, the notes were kind of all over the place and didn't really line up with the text a whole lot. And, you know, it was very difficult then for students to kind of piece it all together in their head. So what I've tried to do is make the videos line up more with the text, and the study guide also line up as well, so it all tends to line up a bit more for you. Don't worry and don't think that, you know, you're somehow deficient if you read the chapter on illegality and then, you know, you kind of close the text and go, oh my gosh, what was that all about? Because it is one of those chapters that you've kind of got to come at, well, for me anyway, several times before things start to gel. But what I would like to do is just a bit of a cook's tour of the materials so that people are a little more comfortable with things before we launch into discussing the actual tute problem. Here we are. So the tute problem this evening involves obviously a purportedly illegal contract. Let us review the principles that we need to review surrounding illegality. Okay, so what are the heads of illegality at common law? The one or two people that have managed to look at the materials. There's a number of them. Well, let's start with the most obvious, the one that I put on the Moodle page today. I'll kill X for $5. Deal. Contracts to commit a crime or tort, they will be illegal, obviously. These aren't relevant to the tute problem, which is about illegality under statute. But I just want to do a cook's tour for you and give you an opportunity to ask questions before we move on. What about, okay, I have a huge salary. I want to get rid of some of that so that I don't get taxed in a certain way. I want to hive off some of that, just in some sneaky fashion. Issues there. Sorry, someone's saying something in the chat box to me. Division 4A. Are you talking, expand on that, Keith? Yeah. Okay, so contracts, well, here we are talking specifically about contract law, and specifically common law, the common law. So yes, there will be provisions under the Income Tax Assessment Act for evading tax, yes, but here we're talking about contracts being illegal at common law for being contrary to public policy. So contracts to here, defraud the revenue. Okay. If I agree to silence a witness in a court case, is that contract going to be enforceable? No. Contracts prejudicial to the administration of justice. If you offer to bribe a politician, contracts tending to corrupt, if I agreed to sell state secrets, and this is becoming more important, obviously. And this last one, I'm sorry, we have to put it in because it's there, and I think it's hilarious. These are the contracts that will be illegal at common law because they are contrary to public policy. Okay. There will also obviously be contracts that are illegal under statute. We'll look at that when we unpack the tute problem. If you have a contract that is illegal, either at common law or under statute, the result is, Latin phrase here, please, people, shout it out if anyone knows it. It was on the top of the Moodle page. Extorpi causa. Okay. Or as my autocorrect likes to tell me, externip cause. What does that mean? It means that there will be, here's something I prepared earlier. It means there will be no remedy for either party. No assistance from the court, no damages, no recovery of amounts due. You can't terminate for breach if you need the court's assistance there. You can't rescind. You can't get specific performance. You can't get injunctions. You can't get equitable remedies. Okay? Illegality by statute. And here, firstly, you might have, ex-ACT Attorney General is in the firing line. Oh, yes, nasty little things. Public officials, I understand that, Keith. Illegality by statute. We might have two different ways that a court might find an agreement is illegal under statute. Firstly, is where a statute actually says if you make a contract like this, X, it will be void, or contracts in relation to X are prohibited, or some such red flag. That will be express illegality. Express illegality. Okay? And that will be a nice, clear-cut case. Is anyone familiar with the case? And I guess since most people actually haven't done the reading this week, you haven't come across the Baird and Magripolis case. Is anyone, I think there was a couple of people that did the readings this week. Baird and Magripolis was the case of express illegality that we tend to default to. What was at issue in that case? Can anybody tell me? No. Okay. All right. We will go through it. In Baird and Magripolis, we had a defendant leasing land from the Crown, and they subleased to two Greek men who couldn't speak much English. There was legislation called the Leases to Aliens Restriction Act, which said it would not be lawful to enter into any agreement for any lease of any parcel of land with any alien who has not first obtained a certificate that they're able to read and write from dictation, words in, and any such agreement. So it just went on there. And any such agreement shall be null and void. Very clear there. In that case, the sublease depended on the sublessees either passing the test and getting this certificate or becoming naturalised. They became naturalised, but the contract was void according to the statute because, it must have been that you had to be naturalised and get this. Okay, sorry. The sublease depended on either passing the test or becoming naturalised. The legislation required them to pass the test. And under the legislation, notwithstanding the naturalisation, the contract was void. That was the issue in that case. The express illegality made that contract fall over. They'd never passed the requisite test. The other form of statutory illegality is implied illegality. And this is where a statute doesn't out and out say that this particular kind of contract is going to be illegal, but something about the legislation tends to suggest that this kind of contract should not be allowed. Okay, here, because there's no nice clear-cut express words, Yango China, I love it. Okay, Yango Pastoral and Chicago. Yeah, first Chicago. Yes, Yango is the other case that we do look at here. So you have to go through exactly what happened on the here. I'll copy this in. Here's something I've prepared earlier. You've got to, where there's no nice clear-cut words in the statute that show you that something's expressly prohibited, then you've got to go through the facts of what's happened carefully. You've got to go through the object of the statute. You've got to go through the purposes of the statute. You've got to look at the prohibition, the section of the legislation that prohibits whatever it is or couches the words for you. And most importantly, you need to look at the penalties and work out if what happened on the facts, if the contract being declared illegal would fall within the kinds of penalties contemplated by that legislation, or would the penalty of a contract being held void and illegal, would that be disproportionate to the best outcome in that case? Would it be disproportionate in terms of the penalties that should be applied in that particular case, given the background of the object of the statute, the purposes of the statute, and so forth? And so, yay, Shona, did you want to yell out briefly what Yango was all about? Okay, we will, here's something I prepared earlier. So we had a prohibition that businesses must not carry on any banking business in Australia unless it had relevant legislative ticks, okay? The penalty for carrying on banking business in Australia was massive, $10,000 each day. Thanks, Shona. It turned up at a royal commission. Not sure where you're going with that. That was weird because of the body clock. What did you want to say there, Shona? Oh, requirements for a banking license. Talk to me, Keith. Wasn't Yango a body corporate lending money? Yes, it was lending money. Was it a body corporate? It was certainly in business. Let's see. Yes. It was body corporate just means company, though. Perhaps are you confused about that? A body corporate just means an incorporated entity, which means a company, a corporation. There are loads of different words. It can be a bit confusing. A body corporate doesn't mean like we would imagine a body corporate under real property legislation. Is that what you were worried about, Shona? Yeah, no, a body corporate in legal terms is an incorporated entity, which means a company. So a company can be called a number of different things. And essentially what it means, and this is interesting, a company is considered to be a legal person, and therefore what are the ways that you invest that new legal entity with the ability to go about and act like a natural person? Well, you would need to give them a body, a corporeal body. So that's where it comes from. If you incorporate an entity, it means that you're basically giving birth to this new entity. And by incorporating it, it means that you are investing it with all of the legal rights and remedies that would accrue to a natural person. So you have the distinction between incorporated entities and natural persons. So far as the law is concerned, they're both individual separate entities with their own rights and remedies. Okay, so that's how we see a body corporate. When we talk about a body corporate, we just mean a company. It has specific meaning in real property legislation, I know. So unincorporated association. Let's not get into company law, Keith. Sorry, effort at derailing this particular tutorial. Sorry, failed. So we talk about Yango in terms of what the legislation was aimed at stopping that company from doing. And the legislation was aimed at preventing any old Tom, Dick or Harry from carrying on a banking business, whether it was a body corporate, as in company, or whether it was a natural person. The aim of the legislation was to just stop unlicensed banking business. So the guarantee that was entered, the transaction at issue was a guarantee. And the question was, is this illegal under the legislation or not? It wasn't expressly illegal. It was not impliedly illegal. And why was that? And this is a really good case for understanding the nature of what a court will do when it's faced with working out whether something is impliedly illegal or not. Because they talk about the aim of the statute and they say, really, what we want to do is just stop this unauthorised banking business. If we actually, and this penalty is massive, but it doesn't increase with each new contract, each new banking contract that a business concludes during a day. It's one capped amount, large amount per day. So whether they concluded 50 contracts or 150 or 2 million a day, they're still going to be paying 10,000 a day during this contravention. So the penalty is more about carrying on the business rather than seeking out to declare illegal every single contract that unauthorised business was carrying on. And what they actually said was, if you prohibited all of the contracts, and this is where they start to look at this, the proportionality of the penalties. If you said, well, this legislation is going to prohibit any unauthorised banking business from creating any contracts, they said that there would be loads of injury to innocent parties. So you'd have employment contracts being avoided. You would have all sorts of other innocent contracts being struck down. And that, they said, was really not intended by the legislation. The nature of, as I said, blanket penalty per day. So this is how the court therefore worked out, well, no, it wasn't actually impliedly illegal either. Yes? Where you have issues of public safety, though, you will find a court much more ready to conclude that a contract may be impliedly illegal. And here we have the Pretorius and Muir case. And in that case, we had the TGA there making any person that sold therapeutic substances that in an unauthorised fashion being guilty of an offence. Okay, an offence, so criminal offence. This is not just a breach of legislation. This is an actual offence. Okay, penalty is $800, so that's a fine, or prison for 6 months. So very severe penalty there for that legislation. And you can understand why, can't you? Because if it was lenient, or you could get around it easily, it wouldn't serve the same deterrent value. Okay, there's issues of public safety here. A plaintiff obviously sold therapeutic substances and was not authorised as required by the legislation, attempted to rely on that contract to obtain payment, and then the defendant said, oh, hang on a minute, impliedly illegal. Yes, it was impliedly illegal, and it was because of these public safety kinds of issues. Okay, again, if you're in doubt about whether or not something is going to be impliedly illegal under statute, then always go back to these things here. All right, I'll make that a different colour. Go through exactly what's happened on the facts. Go through the object of the statute. Go through the purposes of the statute, the wording of the prohibition, and look at the penalties, okay? They're the two main cases that you need to be thinking about in terms of implied illegality, okay? Now, a contract may not be expressly prohibited, and it may not be impliedly prohibited, but nevertheless, it may fall foul of what I call the smell test. Okay? May fall foul of the smell test. And by that I mean it may fall foul of the purpose of the legislation. And this is your Fitzgerald and Leonhardt case. And I really like this case. And the reason why is I particularly like the judgment. Now, I actually have it up on my computer, but I think it'll probably take me too long to share with you. The judgment, and this is just brilliant, brilliant writing here. Dawson and Toohey. No, it's not. That's the joint judgment. Here we go. McHugh and Gummo. McHugh and Gummo's decision is the decision that I really, really like. If you have a look at it on Osley, you will see, well, do you want me to share it with you just very briefly? I'm going to share it with you just very briefly. I can share it at the end, actually, if we've got enough time. The prohibition there was that the bore construction permits were required under this legislation before you could construct water bores in the Northern Territory. Now, obviously, that's a very serious issue in the Northern Territory, which is so strapped for water resources. The owner of land contracted with the driller to construct bores, and the driller was licensed under the Water Act. So the driller was doing the right thing. The owner that got the driller to construct the bores on their property did not have the necessary permits that were required under the legislation. Okay? The driller went ahead in good faith and did the work, and the owner said, "No, sorry, not going to pay." Now, the owner alleged a whole stack of different reasons why they shouldn't have to pay, and it really only came up in oral submissions late in the day, very late in the day, that the barrister representing the owner said, well, and by the way, we think this contract is illegal under the Water Act. And then we had this whole decision then coming down and discussing illegality, the whole nature of illegality. And it's a really nice, nicely set out judgment. And they go through exactly what we've been talking about here. They said, well, firstly, they said, we don't really understand why you never ran it as a case of implied illegality. But in any event, let's have a look at whether, notwithstanding that implied illegality has not been argued here, whether it still falls foul of the purpose of the legislation. And they go through and they look at all of these points here: the object of the statute, the purposes of the statute, the wording of the prohibition, and the penalties. And they say, look, you know what? We don't think that there has been anything about the formation of this contract that would warrant us striking it down. The driller was licensed as he had to be under the legislation. He did the work in good faith, and he just wanted payment. It wasn't even a very large sum. He just wanted payment. The owner was the one that was trying to get out of payment by saying that the contract was illegal. And they're saying, should we impose an extra penalty here on the driller by saying that this contract is now illegal and therefore cannot be relied on to claim payment? And really, it's a case of the court saying, you know what, the owner is the one that's done the wrong thing here. Why should we penalise the driller by holding illegality? We're not going to do it. They don't rule out the fact that there may be circumstances where a contract is not expressly illegal. It's not pleaded as being impliedly illegal, but nevertheless, it may still fall foul of the purpose of the legislation, but this is not such a case. Okay, so I do like that case a lot, and if you're getting a little confused about the differences between implied illegality after you've read the text and this whole issue of contravening the purpose of legislation, then go and have a look at the Leonhardt case. Okay, so whether Peter can have the court declare the contract illegal, let's jump over to our little scenario here. All right. Am I sharing? Am I sharing? Let's see. Start sharing. All right. Main screen. All right. Let's go.
And sit down.
Thanks, love. What did you say your name was, again?
My name is Julia. I am one of the solicitors here. How can we help you?
Well, it's like this. I retired about 2 years ago. Used to be a foreman in a factory down in Victoria. This is back when Australia still made cars, you see?
Sure.
Anyway, I decided another Melbourne winter was going to kill me, so I moved to Queensland. Decided to buy a hobby farm. Found out that hobby farms are boring. Fruit trees just sit there and do nothing.
I guess so.
So I was in a doctor's surgery, and I read an article about Aquabra. You know, the hat company? Turns out they make those hats out of treated rabbit pelts. But they're going broke, because this new virus is killing all the rabbits in their warrens. It's saving the farmland, but killing the hat company. I thought to myself, here's an opportunity. I've got a farm, and they need rabbits.
Did you actually farm rabbits in Queensland?
No. Turns out it's illegal in Queensland. You can't even keep them as pets. So I couldn't farm them.
Thank goodness for that. I thought you were about to tell me you'd been charged.
No. It would be funny if I though. I could be the famous outlaw rabbit keeper, a fugitive from the law. I could even have a costume, with an Aquabra hat.
Oh dear. So if you didn't get charged, what did happen?
Well, before I found out about this ridiculous law, my plan was to farm rabbits for a profit. So obviously I needed a supply contract. I got in touch with a fur wholesaler and contracted with him to supply 1,000 pelts a year for 3 years. It was easy. Like I said, they are finding it really hard to obtain pelts.
Did the wholesaler know you were in Queensland?
He didn't ask, and I didn't say. Anyway, once I found out that farming rabbits is against the law, I went back to him and said we'd need to cancel the contract. He refused. He told me that I'd made a deal, and that he has already on-sold the pelts for the next 3 years. He needs them delivered. So here I am, with a contract to deliver 3,000 rabbit pelts, while my hobby farm is in a place where rabbit farming is illegal. Can you give me any advice?
Yes. My advice is that you should see a lawyer before committing yourself to a contract next time. But I will see what I can do to help you for now. Welcome.
Okay. So, what has happened here? What has happened here? Let us go and, all right. Shoot me the facts that we need to work with here. Everyone switched off their brains for the evening. Where have you gone, people? Come back to me. I have something flashing. Oh. No? No one wants to venture forth? Farming, we do know that farming rabbits is against the law. Farming rabbits is against the law. Here we know that Peter contracted to sell rabbit pelts, not to farm rabbits. So our first conclusion would be the contract is not expressly prohibited. Okay, is it impliedly prohibited? We don't know because we haven't been able to see the legislation. However, are there any guesses that you would make about the legislation? Not really. It's a bit difficult without. I think this particular tutorial problem is quite difficult to properly consider without sufficient knowledge of the legislation that's being cited. However, does anyone know the legislation that actually does exist here? What is it called? Anyone happen to know? Wow, there's tumbleweed and crickets out there tonight, folks, isn't there? We're all being very, very quiet. Keith's saying something. Are you, Keith? Talk to me. No? It's called the Biosecurity Act. And that act, if you have a little look at it, tells you that it is illegal to feed, sell, and release rabbits without a permit. So it doesn't get us much further than this, because we already know that farming rabbits is against the law, according to what we've been told. So there's no express prohibition in there. If you look at it, there's no implied prohibition. So then you're thrown back on this purpose. And you would need to go through the objects of the legislation. You would need to look at the, here, all these things I've talked to, the object of the legislation, the purposes, the word, well, there's no actual prohibition here, and the penalties. And then you would need to come to a conclusion about whether selling pelts contravened the legislation. Now, one would think, would you not, and this is why I wanted to unpack the Fitzgerald and Leonhardt case, that this scenario would lend itself quite well to, and I'm just talking with you now because I appreciate that a lot of you haven't managed to confront the materials. But one would imagine in an IRAC for this kind of problem, what you would need to do is you would need to unpack the Fitzgerald case for me. You would need to tell me the facts and demonstrate a good understanding of what the court said, pardon me, about legislation that contravenes the purpose of conduct that contravenes the purpose of legislation. Okay. I can't, because these facts are a little similar to the Fitzgerald case in that it really was a case of Peter not doing the right thing and ensuring that he was able to farm the rabbits in the first place before he contracted to sell the pelts. I doubt whether the court would come to his aid by suggesting that the Biosecurity Act covered situations like this and therefore rendered a contract to sell pelts illegal. You can see, can you not, that there are parallels between the Leonhardt case and here. Peter's trying to get out of this deal because he finds himself in a predicament and he just doesn't want to follow through with the contract. Same way as the owner just didn't want to pay in the Leonhardt case. So if you don't have anything as clear as express prohibitions, and there is nothing that would flag for a court that there is an implied prohibition, then Fitzgerald and Leonhardt suggests that a court will call a spade, if you will, and will say, well, you know what is really going down here? And is this a problem that the legislation really would seek to avoid? And I would hazard a guess, applying Fitzgerald and Leonhardt, that poor old Peter would be left out in the cold. Does that make sense? What I might do is briefly share with you the actual Leonhardt case. Here, let me just shut this down.
Peter, please come in and sit down.
Thanks, love.
So here, McHugh and Gummo is the judgment that I particularly like. I think it's the clearest in the case. But you see, they get a tick in terms of clarity and they start off very clearly telling us what's going on, that there was this driller that, had his license as was required under the legislation, and drilling licenses were required. You had to be issued by the controller of water resources. You couldn't construct bores, you couldn't extract groundwater and all of that kind of stuff without proper authorisation as required by the legislation. And then they talk about the fact that the Act vests in the Territory the property in and rights to the use, flow and control of water. And obviously, why is that? Because water resources are extremely important in the Territory, right? The owner can take for domestic purposes, drinking water for grazing stock and so forth, but the controller can give directions to control the use of bores, okay? An important right in that part of the world. Now, the owner contracted for bores. He drilled 7, 3 of which were successful. Now, here, the driller then wanted payment. Look at this, not a terribly large sum, but the owner said no for, like I said, a whole heap of reasons, including just for the fact that he wasn't happy. And he was scratching around for any darn reason not to pay. It was only an oral submission that a defence of illegality was raised. So here they're starting to call a spade, yes? And then they go through what was found in the lower court judgments. And then they say, okay, well, was there a contravention? Eventually they say, yes, there was a contravention. and I will leave you to explore that part as you will, obviously, because the owner didn't actually get the right permits that he had to get, okay? So they say this isn't a case where the statute expressly prohibited something. The act did prohibit the owner doing or suffering particular acts without the authority of a permit. An agreement that the owner engage in such activity may have been treated as impliedly prohibited and therefore illegal. But they're saying, huh? They didn't actually plead that at all. Okay? So is there some reason for us to step in, I guess, is the next logical question. And they say, well, you know, the contract as framed wasn't illegal on its face. It doesn't necessarily require any illegality. The statute didn't prohibit anything essential for carrying out the contract. And so they search around and they say, well, you know what? They go through familiar principles in terms of finding things illegal or not illegal. And now here, the action by the driller to recover monies was not an action by a party to a contract who had chosen to perform illegally. The penalty, it should be on the owner. Okay, that's what, oh great, sorry, I'm just getting all sorts of disaster notifications on my computer here. Forgive me if there's something going wrong. It's just flopped back again. Okay, I hope you can all still hear me. So it hasn't been suggested that the driller acted otherwise than in good faith, or that he'd aided and abetted in some kind of offence. So they're starting to not lay the blame, but they're calling a spade very clearly here, and they're seeing through why the owner is actually trying to argue illegality here. The question then becomes whether, as a matter of public policy, the court should step in and decline to enforce the contract because of its association with the illegal activity of the owner. Okay? Not expressly prohibited, not impliedly prohibited. Is there some reason? Well, they've already started to lay the groundwork, haven't they? We see what you're trying to do, Mr. Naughty Owner. And if they let's just be honest here, a court will, when they are talking about matters of public policy, it's not just, well, how naughty is the thing that's going on. It's also what kind of a precedent is it going to set for the future. And if they allowed all owners to escape liability for having bores constructed on their property simply by virtue of not getting the right permit, what message is that then going to send? So there are all sorts of things going through the court's mind here, aren't there, when they are making a decision of this nature. And that is where you need to be frolicking around. And that is why I think, in terms of Peter and the rabbit scenario, and I think it's why, you know, at the end of the animation, the lawyer says to him, look, you know what, next time, get some decent advice before you enter your contract. Because I just don't think that a pleading of illegality would fly here. Does that make sense to you kind of now? Do you see why I like this decision? Because it's very, very clear. They go through Nelson and Nelson. They go through courts stepping in to provide relief and remedy. And it's a very, very nice judgment in a difficult part of the law. So that is the decision in of McHugh and Gummo in the Leonhardt case. I would really recommend having a little look at that judgment if you are finding yourself at odds a bit in trying to understand this whole, trying to get a contract declared illegal, even though it's not expressly or impliedly illegal. And that takes us to what is a conclusion of the main part of this evening's proceedings. I've missed, there's been a bit of activity in the chat box here, struggling with inconsistencies. When stuff gets to court, it's really about the money. Yeah, so tell me about that. Why would the driller agree to drill without the owner having the correct permit? I don't think he knew about whether or not the permit had been sourced prior to commencing drilling. Seems to be a help to the driller who is not commercially astute. I know that causes you some pain, Keith. From our prior discussions on Waltons. Tyler says, if the court allowed the contract to be classified as illegal, then all people who wanted bores would simply not get a bore. Yes, and that's exactly kind of where I was headed with that. And that's partly why I really like that judgment, because it's not often you see a court just really calling a spade like that. And often I'm sure these things float through the court's minds, the judge's minds, but it doesn't actually make it onto the paper. But it's really nice to see them going through that thought process of, well, what, should we step in? Should we not step in? Where do the best policy interests lie? It's just surely that's a matter for the driller. Getting the correct permit? No, it was the owner's responsibility to get the permit.
Yeah, sorry, AJ, but you buy a house, you spend thousands of dollars on legal fees to make sure you have the right whatever. There's no encroachments, that it's not going to be resumed for a highway. It goes on and on and on. The onus is completely on you to make sure that everything you do is right. You buy a car, you happen to buy a stolen car, and immediately you have to give up the car, and you're the completely innocent party. In this case, our poor old driller is purportedly an innocent party. He's just commercially naive. He hasn't checked that the guy's got the right permits. He's in the industry. He's an expert player. He knows that the owner should have those permits. Otherwise, he's drilling illegally.
The issue is, should the contract be declared illegal? So the construction of the bores was on the owner's property and was the owner's responsibility. I hear what you say in terms of being commercially astute, but let's go through. I'm just looking for the beginning of the judgment here. I'm just looking for, there's Kirby there. I'm just looking for the exact, the owner planned to subdivide the land, and it was a requirement that there be a certain flow of water, so he needed the bores drilled. The owner contracted for drilling a minimum of 3, but 7 were actually drilled. It doesn't say how it came about that the local court found that the contract was for the drilling of minimum. With the knowledge and approval of the owner and pursuant to the contract, the driller drilled the bores. The construction, I have a feeling, and don't take me at my word here, because it's been a while since I've read the case in full, but I have a feeling that the owner represented that he had the permits and some were to be forthcoming, and that's why he had authorization for only some of the bores, and the guy went ahead on the basis that they were to be forthcoming. So I think, again, there was some element of naivete.
Correct. I take on an employee and they don't give me a superannuation number, and so I don't have a fund to pay it to. The ATO are going to say to me, sorry, that's your problem, not ours. Here's the 45% charge.
I'm not going to get onto a really long excursion on this, Keith, because we have people that need to be discussing their assignments.
Yeah, sorry, my apologies. You're right.
I appreciate that this is a particular interest of yours.
Yeah, got that.
But there is a very big difference between saying that someone is commercially naive and saying that they deserve no protection by the law, particularly where the only excuse for the owner in not paying was this purported illegality. And the only reason why it would be held to be illegal was because of the owner's own conduct. I understand if there are other valid contractual reasons why the contract had to fall over, but illegality is not appropriate here. You can't stretch this legislation to make that particular contract illegal, given that it wasn't expressly made illegal. Okay, and given that implied illegality was not pleaded. You might have a different case under implied illegality if they properly pleaded it, but it was thrown up at the last minute.
Yeah, okay. I can't answer for the pleadings.
Yeah, so I'm just saying you've got to be very careful in trying to answer from gut instinct and basing an answer on sound legal principle. So even though it really ticks you off that people, in your view, get protection in these kinds of circumstances, to deny protection and to make this contract fall over in this circumstance on these pleadings under this legislation would not be legally sound.
That kind of steps into the area of saying the High Court should never overrule a previous decision. My argument is this is not sound. And I'm not quoting myself with the High Court, please. I'm not taking on that arrogant stance.
If you're saying that the court was wrong in holding this way, I will have that debate with you elsewhere. For the moment, we need to move on to the assignment. I'm just saying to you, I don't believe, as a matter of sound legal principle, that contract in this circumstance should be held illegal. I think this was the correct decision. But why don't you post it on Moodle and see whether we can start a debate?
Nah, I hate that stuff.
Well, okay. That's fine. Let's move on to the assignment.